to the Dershow. Before we get to the subject matter of today, Hunter Biden, a little news update. As you know, Hamas has refused to accept the ceasefire that both the Israelis and the Americans, with Qatar and Egypt behind them, have put forward. Now, where are all the demonstrators, the ones who are calling for a ceasefire, ceasefire, ceasefire? We're occupying Columbia, we're occupying Yale, ceasefire, ceasefire. Has a single one of them called for Hamas to accept the ceasefire? Of course not, because this was never about a ceasefire. The ceasefire was an attempt to bring useful idiots, young people, some of whom actually mean well, into the fold. But the people who are organizing this thing, the last thing they want is a ceasefire. They want dead civilians so that they can try to destroy Israel in the court of public opinion, and particularly on university campuses. And the best proof is not a single demonstrator. Name one. I challenge you. Not a single demonstrator has called on Hamas to accept the ceasefire. All Hamas has to do is say, yeah, we'll do it. And we're going to get, weeks and weeks of peace, and we'll return whoever is left, just a few hostages. Because remember, under the deal, all they're going to return is the elderly and women, and how many of them are still alive. We know that Hamas has executed. We know that they've raped some of the people. But you wouldn't know that watching, for example, Jon Stewart. Jon Stewart, he's a comedian who nobody laughs at. Jon Stewart doesn't tell funny jokes. You don't laugh at Jon Stewart. You clap at Jon Stewart. When you clap at a comedian, it means he's not funny, but you approve of what he's saying. There's a book some comedian wrote, don't clap. Either laugh or don't laugh, but don't clap. But with Jon Stewart, people clap because they approve of what he's saying. But what is he saying, Jon Stewart? He's saying there are no hostages. He hasn't mentioned hostages in all of his rants and raves against Israel. No mention of hostages. When's the last time he talked about people being raped as a tool of war? No, Jon Stewart is one-sidedly anti-Israel. It's interesting because people say, oh, he's Jewish. So if he's Jewish, his name was Jonathan Stewart Leibowitz before he chopped off the Leibowitz. And now he's, the big thing is, I'm Jewish, I'm Jewish. So obviously what I say against Israel must be true. No, what you say against Israel is A, lies, B, lies by omission, failing to put the onus on the other side for having started this and for having taken hostages and for not returning the hostages. And so, three boos for Jon Stewart and for anybody who is demonstrating against Israel, who isn't now demonstrating against Hamas, demanding that they accept the ceasefire that these protesters claim they were interested in all along. What a bunch of phony hypocrites. What a bunch of frauds. Okay, another news item. President Trump's lawyers have now naturally asked to end the gag order. What possible justification is there for a gag order after the trial's over? You can't intimidate witnesses once the trial is over. There never should have been a gag order. There already are statutes making it a crime to intimidate witnesses. There was no basis for it at all. And there's no reason why Trump can't, for example, in his debate, bring these things up. After all, Biden has brought them up, and he probably will bring them up in the debate. And probably the Democrats are going to try to run against the convicted felon. And so obviously Trump should be allowed to exercise not only his First Amendment rights, but my First Amendment rights and yours. Because remember, the First Amendment has two sides, his right to speak and our side to listen. And if he's denied the right to speak, we're denied the right to listen. So even this judge might do the right thing here and say, all right, the trial's over. There are some questions about whether I should have or shouldn't have imposed a gag order, but now there's no possible basis for a gag order. If the judge doesn't eliminate the gag order here, basically we know what we already know, how one-sided, incredibly one-sided he is. Okay, so let's turn to Hunter Biden. The fascinating thing about Hunter Biden is he's charged with almost the same crime as Donald Trump was charged with. He's charged with making a false entry. Essentially, Hunter Biden is accused of signing a statement, checking a box that essentially says, no, he wasn't addicted to drugs and he didn't use drugs in order to get a gun permit to purchase a gun. It's similar, except of course that what Hunter Biden did was clearly wrong. He was addicted to drugs. How do we know? Because he said so in his own book. And when he read his book, he said it in his own words. The Trump thing is much, much more complicated. It was a legal expense. He was paying to avoid a lawsuit and paying to avoid damage to his business. And it was a legal expense. And probably it was entirely deductible. We'll never know that because he didn't deduct it. But there are similarities. And it'd be interesting to see if there are similarities in the outcome of the case. Look, there's no doubt that Trump could not get a fair trial in New York, and probably he couldn't get a fair trial in Delaware, because Delaware is overwhelmingly not only Democrat, but obviously Biden territory. So the real question now is whether or not prosecutors, if they're really prosecutors, because they're, Justice Department prosecutors, they're the Biden administration prosecutors going after Biden. We'll see whether they're soft on him or tough on him. But whether they can get a fair trial in Delaware, or whether the Biden influence is so pervasive in Delaware, Biden's wife is at the trial, and I don't blame her. That's a perfectly reasonable thing to do for a stepson. But the question is, will the jurors, who probably are overwhelmingly pro-Biden, vote pro-Biden, just the way the jurors who were overwhelmingly pro-Biden voted pro-Biden in New York? There's a famous statement, geography is destiny, and that usually relates to geopolitics. Poland always stuck in the middle between Russia and Germany and Ukraine. Geography is destiny. But that's also true in criminal cases. Geography, in the context of criminal cases, is called venue. Venue. The Sixth Amendment to the Constitution requires that defendants be tried in the district in which the crime has been committed. Why Trump was tried in New York is a different question, because the alleged crimes were, not New York focused particularly, although the company was located in New York. And of course, the crimes that Hunter Biden was charged with are located both in Delaware and in California. And there's another trial scheduled for California, I guess, at the end of the summer. But it'd be interesting to see how this trial progresses in Delaware. First, let's start with Hunter Biden's lawyers. He's very well represented. He's represented by Abbe Lowell, who's a great lawyer. I've worked with him on cases. He is top-notch. He's not going to be taking orders from the White House. He's going to be doing what's best for his client, which is Hunter Biden, but as his client defines it. And his client may define what's best for him as what's best for his father. There was a plea bargain, and the plea bargain would have satisfied the father and would have satisfied the son, but it wouldn't satisfy the judge, and it wouldn't satisfy the public, because it was too much of a sweetheart deal. Again, I praise Abbe Lowell for getting a sweetheart deal, but then the judge kind of tore it apart. And then the defense said, well, it really doesn't cover everything. Maybe it means they can reindict and reinvestigate. So in any event, it fell through. I'm going to make a surprising statement here, and it's only speculative. It is conceivable, very unlikely, conceivable you could still get a plea bargain. I've had cases, and I've seen cases where plea bargains were struck in the middle of trial. There's a famous case where the jury was out and nobody knew whether they come back guilty or innocent. And an hour before, or even less, before they came back, the defendant pleaded guilty. And then, shock upon shock, the jury acquitted. But it was too late. The jury acquittal meant nothing because he had already pleaded guilty. And he went to, I don't know if he went to jail or not. I don't remember that. But I do know he was found guilty. He entered a plea of guilty for a crime which the jury ultimately found him not guilty, but the jury verdict was moot because he had already pleaded guilty. So you can make a deal at any point. I've made deals after convictions as well. I've made deals to avoid appeals or to avoid certiorari. So the casino is always open when it comes to criminal justice. You can always put your bet down. You can always double down. You can always do whatever you do in a casino. You can always bet, and sometimes you win, sometimes you lose. The big difference is that when you have a plea bargain, mostly it's a draw. It's like what we used to say as a kid, kissing your cousin. Mostly neither side is satisfied. Mostly each side thinks they gave up too much. But that's the nature of a plea bargain. That it's the nature of all kinds of bargains and all kinds of deals and all kinds of negotiations. So we'll see. It looks like this case is going to go to verdict. But as I said, it's not inconceivable that there could be a plea bargain even late in the game. So what's the strategy? The defense strategy, it seems to me, is fairly obvious, but I don't know all the facts. I don't know what is in discovery information, and I do know the law, but there could be some things that we're just not aware of, but the obvious defense is, he didn't write down that he was a drug addict or he was using drugs. Of course, he didn't write down that he was using drugs and he's a drug addict, because one of the major symptoms of being a drug addict is denial. And so that's obviously going to be the defense, that he was in denial, that he was under the influence of the drugs when he didn't list that he was under the influence of the drugs. I don't know whether the defense will put on expert witnesses. They certainly should. And it's a defense that might work in Delaware, because you're going to get a sympathetic jury. There was a report today on one of the news channels that one of the jurors was wiping her eyes, was tearing up when his drug problems were described. Everybody in Delaware and in many other parts of the country knows somebody who's in trouble because of drugs, whether it's because of illegal drugs or because of overprescription of lawful drugs or improper access to lawful drugs. America is an addicted country, and there will be reactions. There will be some people say, oh my God, there's so much addiction, so much drugs in this country. We have to really get tough and punish somebody who didn't list those things in his form. There's others will say, there but for the grace of God, go I. And there might be some, interestingly enough, there might be some Second Amendment people on the jury, very strong supporters of the right to bear arms, who might say, what's the government's business, whether we're drug addicts or not? We have the right to have guns. You might get some gun sympathy, you might get some drug sympathy, and you might get some Biden sympathy. And the defense attorneys, who are excellent, will play up to all of those factors. And even though the case seems clear on the facts and the law, that is the physical facts and the law, there is a mental element here. You have to prove that what he did was deliberate and willful and knowledgeable. And if the jury has a reasonable doubt about the fact that, he was somehow in denial and repressing and psychologically incapable of indicating that he was using drugs, I could see a jury verdict in favor. I can also see a jury verdict which was essentially jury nullification and civil disobedience, saying, I don't know, this poor guy's been through so much. His father's running for president. We want him to be president. We don't really want this to be election interference or disruption. Yeah, I know if the shoe were on the other foot, maybe we come out differently. But what the heck? Let's either have a hung jury or an acquittal. So I think it's certainly possible that you may get a non-conviction verdict, even though the external facts, the fact that he signed, yes, although I think there's some view that maybe he didn't sign, that the owner of the store signed it for him, but he was responsible for the signing. And he was. There's no doubt that the statement on the form was not true. Those facts are not in dispute. And Abbey Lowell's a good enough lawyer not to contest those facts. He won't make the same mistake that Trump made, denying that he had sex with Stormy Daniels. I don't think very many people believe that denial. It wasn't relevant. It was utterly irrelevant in the case, and he shouldn't have had to deny it. But perhaps he shouldn't have denied it. But I don't think we're going to see any denial of the overt facts in the case. I think we're going to see an acknowledgement that the physical facts do point to guilt. That is, the elements of the crime are met other than the element of intentionality or knowledge or willfulness. Those are required elements for a crime like this, especially because this crime, if there's a conviction, carries a pretty substantial sentence. It's not going to get it. I don't think if there's a conviction, there'll be a prison term at all. There would obviously be a fine, although I can easily see a judge saying, look, he had a plea bargain. A plea bargain would have avoided prison term, but the plea bargain is no longer in existence. So we have to give him something more than he would have gotten under a plea bargain. I can see some judges doing that. I don't know very much about this judge, except that, what she did do in vacating the plea took a lot of courage and a lot of guts, particularly in Delaware. So we just don't know what the attitude of the judge is. We have every reason to hope that it's not Judge Marchant revisited, because that would be terrible. You may know that the New York Times had a piece the other day by the former assigning judge of the New York Supreme Court, basically giving a funeral oration or a Nobel Prize speech for Judge Marchant, saying he's the greatest judge that ever lived, and this was the greatest trial, in history, with no problems at all. Quoting me, actually saying, "Oh, well, Dershowitz says that he didn't do well in dealing with the judge, with the lawyer Costello, but he's wrong. Dershowitz was wrong." So I wrote a letter to the Times, showing that I was not wrong. But we'll see if the Times publishes it. I just sent it today, so if it's published, it'll be in probably the day after tomorrow. But I took a pretty strong view against that column in the New York Times that praised Judge Marchant for what he had done. I think the writer, the judge who wrote the thing, called it a kind of model. Oh God, if that's a model of justice in America, we're in really, really deep trouble. But I hope readers will read his article with a critical mind, and will read my letter if they publish it with an equally critical mind. So, we're into trials. This is the season. To everything there is a season, said Ecclesiastes. And the season of trials, the season of political trials, is upon us. Within 1 week, we have a trial of the former and perhaps future president of the United States. We have the trial of the son of the current president of the United States. We have the ongoing trial of the senator from New Jersey, who's a really nice guy. I've met him, know him, like him. But we'll see. We'll see what the evidence is. The fact that there were gold bricks in his house is not evidence of guilt. People own gold. I own some gold, not a large amount. I don't own it. I don't have it. My stockbroker has certificates or something. I've never seen the gold, but people own gold as a hedge against inflation. So that itself is not evidence. But we'll wait and see. He's on trial. His wife's on trial, and we're living in an age where you cannot trust the legal system. And again, I want to emphasize how wrong President Biden was when he talked about how you have to trust the judiciary. He didn't talk about how you have to trust the judiciary, by the way, when the Supreme Court overruled Roe versus Wade. He attacked the judiciary when that happens. And so, you get the selective approach to attacking or defending the judiciary. If you like the results, hey, don't mess with the judiciary. There are judges. If you don't like the results, you call for their impeachment. I remember when I was growing up, they were calling for the impeachment of Earl Warren for writing the decision in Brown versus Board of Education. And now we're seeing calling for the recusal of justices of the Supreme Court whose decisions they don't like. Same people are saying, oh, but Judge Marchant shouldn't have been recused. We need single standards of justice. We need a return to principle. And damn it, we're not getting it. We're not getting it. We're moving further and further and further away. And this horrible verdict in New York in the Trump case is the furthest we've moved in a long, long, long time. And let's wait and see. Let's wait and see what happens in Delaware, where you have a trial. Much more, the evidence is much more compelling against Hunter Biden than it was against Donald Trump, but it's Delaware. So we'll see. Keep an open mind, keep an open eyes, open ears, and be prepared to criticize. Do not ever withhold criticism of the judiciary. They are as subject to criticism as any other branch of the government. All right, let's look at a couple of letters. House arrest would rightly be viewed as campaign interference. Of course it would be. I mean, the idea that you tell a candidate for president that he has to stay home, obviously, if there were house arrest, it would be stayed. But what if he gets elected? Then house arrest means he's relegated to the White House. He has to stay in the White House. Wasn't it Jimmy Carter who campaigned from the White House? He didn't leave. I think it was during the hostage crisis or whatever. I don't remember exactly. But house arrest in the White House. That's a very, very interesting concept. Since when do judges determine our elections? Well, that's the problem. It's not only judges, juries. What's the worst thing is that it's prosecutors. It's prosecutors, because under American law, Justice Jackson, the great Robert Jackson, said this many years ago. He said any creative prosecutor could rummage through the statute books and find crimes against virtually anybody. And that's certainly true of anybody in business. Anybody in business who has to list things and make statements. And if a prosecutor wants to find a crime, a prosecutor can. And that's only gotten worse after the New York case, because the prosecutor went through all the statute books and he couldn't find the crime, so he made one up. He added 1 + 1 and he got 48. But it's absolutely true that prosecutors can today have an outsized influence on presidential elections. Okay. An emergency appeal to the Supreme Court to delay sentencing is needed. Problem is, it can't be done. The Supreme Court doesn't have jurisdiction over state cases while the state cases are pending, except in extraordinary circumstances, and this would not be one of them. So Trump's going to have to wait. He can try to move the pre-sentence report earlier and try to move the sentencing earlier and then try to move the appeal earlier, but he's going to have to go through the New York appellate process before he gets to the United States Supreme Court. Okay. And we don't know how the United States Supreme Court will deal with the case. The first most important question is, would they grant review at all? Would they grant certiorari? If they did, I think they would reverse. But whether they would or wouldn't grant certiorari is the hard question. Okay. I'm a 71-year-old retired MD who was previously a member of the Democratic Party. The current leaders of the Democratic Party are leading us to a very dangerous path in national and international matters. I very much appreciate your time and energy in analyzing these issues. Look, that's all I know how to do. If I were a younger man, I'd be out there doing other things. Certainly, if I were 25 years old today, I think I'd be volunteering to fight for the Israeli Defense Forces. But I'm not. I'm 85 years old, and I'm stuck with my pen and hopefully my mouth and my ability to try to influence some of you. By the way, I want to thank some of you. The numbers have been phenomenal on our show. We're getting 200,000 viewers and sometimes more, 300,000 viewers. It's been up even beyond that. And that's just great. I really do appreciate having an audience, and I appreciate getting your letters, even the letters that attack me, and many do. I think the most frequent attack is, why am I still a Democrat? And why don't I immediately announce that I'm voting for Trump and endorsing him? That comes from a lot of people, including President Trump himself, who has asked me that question on numerous occasions. I have no presumption at this point in favor of either candidate, and I'm gonna wait. I'm gonna wait and see what it looks like. Um, President Biden is obviously doing a lot of things politically now, closing the borders, which probably he has no right to do any more than he had the right to open the borders. These are legislative determinations, not executive determinations. But we're seeing the executive and the judiciary taking over more and more functions that are supposed to be legislative functions, and that's not good for democracy. I'm glad you stand ground. I wish more leading legal experts would speak out. You don't look 85. Thank you for being honest and outspoken. Yeah, I feel 85. I'm speaking tonight to, they tell me 600 people. I'm going to Chabad, the Orthodox Jewish Zion, pro-Israel organization in my wife's hometown. And so I'm going to speak to them and try to keep up my energy as much as I can. And I try to tell people what they don't want to hear. That's why I get invited everywhere to speak once, because people want to hear confirmation. They want to hear what they approve of. And I don't often give them that. I give them hopefully something to think about, something to argue with, but not generally something to clap about or approve. I am not Jon Stewart. Okay. Um, let's see. I'm glad you stand your ground. I wish more leading experts would do it. Why don't you leave the Democratic Party, do what Joe Manchin did, and consider yourself an independent? I am really an independent today. I mean, I'm independent minded. As you know, Donald Trump got in front of the courthouse, was a week ago or so, and said, any Jew like Alan Dershowitz or any supporter of Israel like Alan Dershowitz who supports Joe Biden or doesn't support me has to have his head examined. And my response was, if my head were examined, you'd find an open mind. So that's what I'm going to do until the run up to the election. And then in the run up to the election, I will make an endorsement and you'll be the first to know it. Okay. Um, um, let's see. Anything else? No, I think that's about it for the letters of the day. But I really, really appreciate your sending the letters because they make me think, and some of them shake me up, and some of them I don't like. But I read them, even if I don't like them. I don't read many of them that are just foolish and utterly unintelligent. But most of my correspondence is fairly intelligent from people I agree with and some people I disagree with. So keep writing. I'll keep talking. We'll keep arguing, and we'll agree sometimes and we'll disagree sometimes. I'll see you tomorrow.